Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. Although the courts have come a long way in trying to eliminate gender bias from its proceedings, it is still no easy task for women to achieve credibility in the courtroom. This is especially evident in cases involving rape and domestic abuse. Today we'll look at this issue with our guest, Linda Fairstein, Chief of the Sex Crimes Unit in the Manhattan District Attorney's Office, and Lynn Heck Shafran, Director of the National Judicial Education Program for NOW Legal Defense and Education Fund. Hello, Linda. Hello, Lynn.
Hello. Alan.
Linda, you're in the courts every day. What's the status?
Well, I think the good news is that things have changed an enormous amount in the last 2 decades, as I like to remind my friend Lynn, but there is great progress that needs to be made, and it is still, I think, the most difficult kind of case, whether it's sexual assault or domestic violence, for a victim to go through the criminal justice system. And although the laws have changed significantly in the last 2 decades, public attitudes about the crimes have not significantly changed, and so the jurors, the people who sit in judgment of the victims, still tend to be very, very critical. And the piece that Lynn does, and she will talk about, we still have all over the country problems frequently because of judicial attitudes about the crimes and the victims.
Let's address that. How do you find judges here?
Well, I would say across the country that things are much better, and I want to reiterate what Linda said, because I think there's a very important balancing point when you talk about this kind of case. You have a listening audience, which unfortunately will include people who at some time in their lives, either they or their loved ones will be a victim of a sexual assault, and they're going to have to make up their mind whether they're going to go to Linda or her counterpart in their own county. And although my work involves focusing on the problems and improving them in the courts for the prosecutors and the defense attorneys, that there's a fair trial across the board, I don't ever want to give the message that things are so terrible for a victim of rape to go through a trial that they just shouldn't do it. So again, I want to underscore what Linda said. Things are better. Now what's bad, again, I mean, Linda picked up on the issue around the jurors. The judges, I find, as I do judicial education on this issue across the country, of course there are some no one ever will reach, but I find that when I come in with national experts on victim impact in rape cases, on sex offenders and sex offender treatment, the judges are deeply interested in this material and deeply appreciative of it. What really stuns the judges, we put on panels of people who have actually sat as jurors in sexual assault cases in the particular state that we're teaching in. And when the judges hear, you know, out of the mouths of babes, out of the mouths of jurors, what these jurors say about how they analyze the evidence or what they thought of the witness, they're just appalled. And our purpose in putting on these jurors is to communicate to the judges that if they do not conduct or permit a thorough voir dire when that jury panel is being considered, then they might as well fold up the tent, because there won't be a fair trial.
Linda, how does the system deal differently with someone who has been a victim of date rape as opposed to a brutal assault?
Yes. I mean, many states distinguish actually between the crimes that can be charged in a stranger case and an acquaintance or date rape. And we don't do that by law in New York. So once you have evidence that a forcible crime has been committed, it doesn't matter legally whether the assailant is someone the victim knows or a stranger. But how in reality she's treated in the courtroom is entirely different. Assume that the victim has survived the assault. The crime has gone to the police and made a report. The stranger rape victim will do very well in a court of law. People tend to believe her, both her personal support people and law enforcement. She gets medical attention promptly, generally, and when the assailant is caught, those cases usually have strong identification value because the victim has been forced through such intimate contact, probably will have DNA evidence and technology now in this day and age, which is a wonderful tool for the prosecutor and therefore for the victim. And she'll do well in a court of law. The acquaintance, and especially the date rape victim within that acquaintance category, is still blamed. You've heard the expression, the blame the victim defense. Those are the cases in which the victim will be blamed by the defense attorney for some part of her conduct that he will try and imply led to the occurrence of this act. So the first line of attack is either that no crime occurred, it was just consensual sex and she's making it up or overreacting, or if he is convinced that the jury will believe that the sexual act occurred, then that she's scorned or fabricating the attack for some reason, when all the classic women scorn kind of things.
And how do you find juries reacting to the difference?
Oh, well, I mean, there's very substantial actual research that's been done, very serious sociological research, in particular a study that was done in Indiana where the sociologists actually sat down and interviewed for 90 minutes each 331 Indianapolis men and women who had sat in sexual assault cases. And right down the board, they didn't want to convict if the parties had known one another before the alleged assault. They didn't want to convict if the woman had ever had sex outside marriage. They didn't want to convict if the woman drank or took drugs. They didn't want to convict if the woman had a blue-collar job. And they definitely didn't want to convict if the woman was black. Terrible racism against black victims in sexual assault cases.
What kind of signal does that send out to the victim who's sitting in her living room now, deciding whether or not I should report the crime?
Well, again, that's why I so strongly wanted to underscore what Linda said at the beginning. Linda will tell you that she is getting verdicts in cases like this. I remember a couple of years ago, didn't you tell me you got a verdict where both parties had been drinking and doing cocaine?
Yes, we get them all the time. I mean, there are a couple of differences that Lynn's pointing out that I think really are critical for your audience to understand. It's better to handle these cases in a large urban area like New York, where the public attitudes are much more open to alternative lifestyles like drug use or even prostitution as victims. I think one of the things that surprises people who are victims most is that we are taking these cases. I'll go to a speaking engagement and somebody will raise their hand and say, well, acquaintance rape cases aren't prosecuted frequently. 90% of what we do in courts in the jurisdictions in New York City are acquaintance and date rape cases. The stranger rape cases frequently plead out, not lesser pleas, but because there's fingerprint evidence or DNA evidence. So we go to court all the time and are making it better.
Help us. Tell me what is a date rape and what is not a date rape.
Okay. The stranger category is obviously any case in which the victim and her assailant did not know each other before the crime occurred. But acquaintance rape is a little confusing because most people use it synonymously with date rape. And it's much, much broader. I mean, acquaintance rape encompasses all of the domestic categories because the victim knows who her attacker is. So it's domestic, familial, incest, those are all acquaintance rape. You get, of course, the date rape cases, people who are on a first date, people who've had a long social and sexual history, but you also get a fascinating category of cases, which is enormous. I call them professional relationship cases. You're lawyers, doctors, dentists, teachers, clergy who have forced or deceitful relationships with clients and patients, and they are an astoundingly large part of our population.
And I want to mention something that's tremendously important about this issue. Counterintuitively, people who are raped by someone they know usually have more severe and longer lasting psychological trauma than the individual who's raped by a stranger. Part of that is because of what Linda said before. The person who's raped by a stranger, and let's say the woman who's raped by a stranger, because even though men are certainly raped and are rape victims, they very rarely, if ever, bring their cases into court. The woman who's raped by a stranger gets support from her family, from her community, from the police, from the health people that she goes to. And how you are supported by the people with whom you come in contact after this event is tremendously important to how well you recover. And then what happens in the acquaintance rape or the date rape or the family rape situation is that the victim totally loses her ability to trust anybody ever again. She feels, I trusted this person, I went out on a date with him, or he was my teacher, or he looked like a nice guy, so I let him drive me home from the wedding. And then she begins to question her judgment about everything. And this is, as I said at the before, highly counterintuitive, because people just make the assumption if you jumped in the dark, that's going to be worse for you than if you're driving home from a wedding and the groom's cousin goes at you.
Linda, give us information. Tell me what you're dating someone, you're going out with them. Let's assume you've had sexual intercourse with them before. What is rape? What constitutes rape? What constitutes a relationship? In other words, what should the viewers know when you cross that line? What is that line?
That line is when a woman is not consenting to the sexual act, when the defendant uses force or the threat of force, whether he expressly threatens her or impliedly by his actions. And if she has said no or communicated her unwillingness to participate in the sexual act, then it is forcible rape.
And then we have a whole new category and growing category, rohypnol.
What is that?
That is, Linda, why don't you describe this in detail and talk about some of the testing that needs to be done immediately when someone thinks she's been a victim?
Right, because I think the most important point to make to anybody listening is whether it's a stranger or an acquaintance who's attacked you, tell somebody, do something about it, and ideally get medical attention. Lynn's talking about rohypnol, which is what's being called the date rape drug. And it's a drug that has been used by offenders, generally slipped in an alcoholic drink so that the victim doesn't know she's ingesting it, and she loses memory of the events and can't respond to anything, generally passes out and then has no memory of the events that occurs. And it's being used, we're told, on a lot of college campuses. There have been several cases in which there have been convictions in other states, none that I'm aware of yet in the New York area, with victims who've been given against their will, without their knowledge, this drug, which incapacitates them. The problem is it only stays in the bloodstream for a very short period of time, and a victim who wakes up, doesn't feel well, gets home, realizes she's been drugged, and then doesn't get medical attention, we can't prove that something was administered against her will. If she goes to a hospital and has a blood and a urine test, and the laboratories can detect the presence of this drug. There's been enough outrage about it that the companies that make the drugs are now literally have just announced that they're going to be changing the color of the drug so you can see it in a drink. It's now colorless, and the texture of it, so when it breaks up in a drink, the victim will know that she's ingesting something other than her beverage and perhaps stop drinking. But it's a very recent new trend and a terrible one because it's being used by predators against victims to make them...
Lynn, are there still studies where women are not coming forth after they're being raped?
Oh, the vast majority of rape victims never come forward.
In acquaintance cases.
Yes.
I think it's very different, if I can interrupt, to stranger cases.
Right.
Most people make an outcry, but acquaintance cases...
You went on a date, and you had a terrible
The data
situation.
show that less than 20%
Oh my, 1 in 5.
of rape victims ever make a formal report. And the data also show, as Linda just said, that if you look at who that 20% is, the significant majority of the 20% will be women victimized by a stranger. Individuals victimized by someone they know, family members, dates, teachers, the professional category, very rarely come forward.
Can you be raped by your husband?
Sure, I mean, that's
Is
a
that a
large
crime?
part. Yes, it's a crime. I mean, domestic violence, as you know, many of your listeners now know a lot more about, frequently includes or begins with psychological abuse and verbal abuse, battering, physical abuse when it escalates, and it's almost impossible to have that dynamic going on in a relationship without there also being forced sexual acts. Whether or not a victim has, and the whole domestic area is even more underreported, as Lynn knows, than
and even
acquaintance
because
cases.
People who work with victims of domestic violence are either not well schooled in the fact that sexual assault is so frequently part of this, or else they don't feel comfortable asking about it, or the woman herself doesn't feel comfortable talking about it. So this is vastly underreported, underdiscussed.
Linda, let's tell our public, what does, if a woman is raped, and let's just take this for the consensual, that they know not consensual, but they know the party. Right. It's a date or a relationship. What can she expect if she comes to your office? What can she expect if she goes to the police?
Okay, I think she can expect much more, much better treatment than every made-for-TV movie and book and the old history used to be. And that's true of every prosecutor's office in every county of this city and surrounding counties has some kind of special unit. The police departments have special units. What the victims need to know is they've got to tell somebody, make an outcry, get medical treatment.
Tell somebody, you mean by the
ideally,
official or
I think law enforcement,
medical provider.
But if your listeners aren't ready to trust that bridge yet, but decide after 3 or 4 days that they want to, their best line for getting into the system is that they told someone right away. So the attack
And
is
if possible, even if they don't want to go to the police, if at least right at the beginning they would go to a hospital emergency room and have a rape kit examination done. Most of these examinations now are done by specially trained nurses, in particular some doctors, called
Evidence is
sexual
collected.
assault examiners, and they collect critical evidence that is lost if time
We'll
is
continue with this
wasted.
conversation right after this break. You're watching Lawline. Stay with us.
Why would anybody give someone they don't know a gift? They do it because this gift saves lives. And the need for it is desperate. We need over 20,000 people to give this precious gift every day. Please give blood. There's a life to be saved right now. Call the American Red Cross at 1-800-GIVE-LIFE.
It's only a little motor oil.
What difference is one drop of paint going to make?
This much fertilizer isn't going to pollute anything.
You're looking at a sea of excuses, created drop by people like you and me. Our waters can be saved if each of us does their part. Drop by drop. If we all do a little, we can do a lot. Brought to you by the Natural Resources Defense Council, the EPA, and the Ad Councils of the U.S. and Japan.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. We're talking about sexual assault. We have Linda Fairstein of the Sex Crimes Unit of the Manhattan District Attorney's Office and Lynn Heck-Shaffrin, Director of the National Judicial Education Program of NOW, Legal Defense and Education Fund. Linda, right before the break, we were discussing what a woman has to expect, and you basically told me what happens before court. What does she expect in the courtroom?
Easier for a stranger rape victim who has survived a terrible life-threatening assault because people think that stranger rape is the worst crime that can happen to themselves or their loved ones and are very willing to believe. Her credibility is rarely attacked. The issue is who the
But on date
assailant
rape,
is.
what can they ask me? What kind of questions can that defense lawyer throw at me?
Far fewer than you think. The rape shield laws really go a long way to protect the victim. We can get a ruling in advance to limit the questions, and in part because of the great work Lynn's done with her project educating judges, we can limit, because there is law, it's not a fishing expedition about a victim's prior sexual history. And we can control that the events about which she's being questioned are the events of the case in the overwhelming number of cases, 99% of the cases that go through the system. And the victims in these cases do far better than was even possible to do 10 years ago. And I urge people to come into their local courts and watch the trials because they're going on all the time, and victims do succeed. We just had a conviction a couple of weeks ago with a dentist who molested patients while they were anesthetized. And it's the kind of case 10, 15 years ago, one of his victims called up and said, this same dentist molested me 15 years ago and nobody believed me, and my family discouraged me from going to the police. We can do marvelous things now with these investigations, and people are much more willing to understand who these offenders are, the scope of these crimes, and how serious they are.
If the viewer has been a victim of a sexual assault, must they go to the police immediately, or if this happened 6 months, a year ago, 2 years ago, can they still go to the police?
Well, there are statutes of limitation, and it's 5 years. Now, the sooner you go to the police, the more logical it is that we'll be able to build a case, enhance a case through very creative investigative techniques that we've developed. The longer you wait, the easier it is for the defense to try and argue this is a recent fabrication. If she didn't care about this for the last 2 years, why should you 12 people be incensed about it now?
But the thing is, what you can do is, someone delays, and then Linda puts on an expert witness to talk about the fact that even very lengthy delays in reporting sexual assault are typical of the victim. It doesn't mean someone's automatically lying. I mean, I think of one case that I read about recently where a woman went to visit her boyfriend, and he worked at night. She arrived there and went out drinking with a buddy of his. Went back to his trailer, her boyfriend's trailer, went to sleep, woke up with this quote-unquote friend attacking her. She didn't want to tell what had happened because her boyfriend and the man who attacked her were very close friends, and the boyfriend his trailer was parked on land that was owned by the assailant. And she was terribly upset about what would happen. Her boyfriend would have no place to live and park his trailer. This friendship would be broken. What should she do? Well, finally, she did come forward. But there are very good reasons why people wait sometimes a very long time to disclose.
If there's a compelling reason, that will help. But if there isn't, and sometimes it is, I don't mean to downplay the psychological trauma, sometimes it's simply the victim's inability to cope with telling. That's much harder on her at the trial because the defense will play on the fact that she didn't tell someone or do something. So the sooner you do something, make a statement to somebody, get yourself treated, the better it is.
And again, I want to reiterate, the sooner you go to a hospital and get a rape kit, because then if you want to mull over and think about whether to report, at least the physical evidence has been collected.
Linda, in the case where, again, it's a date situation, and it boils down to the tests have not been taken, and the victim did not tell anybody. Does it come down to a contest of he said, she said, in many instances?
Yes, I mean, if you think about it, in almost any kind of trial that involves living witnesses, I mean, not a homicide, that's all you need in any case. I mean, the credible testimony of the victim is all that's required by law, and as Lynn knows, I mean, a lot of us fought a long time to eliminate very archaic laws that required something else. It's always nice if there is more corroborative evidence, whether it's in the form of things that are consistent after the attack with having been the victim of a terrible assault. But yes, many of the acquaintance cases are only the testimony of the victim or witness. And so how candid she is, how credible is critical. And Lynn mentioned alcohol and drugs. That's frequently a problem in date rape cases, because in 70% of date rape cases reported nationally, at least one of the parties has been using alcohol or drugs, and in 30% both parties. And it just makes it obviously harder for the victim to get out of a situation that becomes dangerous, and it certainly makes it harder for her to recall details.
Under what circumstances will you not prosecute?
If we don't have a credible witness, but if we don't need anything other than a victim's word, and we will try a case with the word of a victim without any other physical evidence.
I want to ask you whether you would have prosecuted the following case that I read about a while ago. A woman in Maine went to a party. There was a Navy base, and there were a large number of young sailors at this party. She found herself in a bedroom with 5 sailors. And she had sex with them because she said that she feared for her life. The mere presence of these 5 men was very frightening to her. The local prosecutor declined to bring any kind of a prosecution. He said there was no violence. She acquiesced. Nobody threatened her overtly. And her claim that just being in a room with these 5 guys, and she knew that they would beat her to death if she didn't acquiesce, was not enough for him, that he wouldn't take it to court. Tell me what you think about that case.
It's an excellent question, and you as a good lawyer know that I need about 5,000 more questions answered before I can answer your question.
But basically,
certainly, well, we can argue a quote totality of the circumstances thing, but I need to know what was her conduct with them before she went into the room, and was there any consensual sex? Was there any overtures? Did she go in? If she was just in a room with them, and I mean, you know, I can't answer this question. I don't know what they said to make her undress, how they compelled her.
Did they prosecute?
No, I'm saying this woman said, I acquiesced because being in a room with 5 guys, I knew that they would beat me up if I said no.
What's missing is the language. What did she acquiesce to? What was the language? I mean, I can see, I could argue this both ways.
The prosecutor said the mere presence of 5 men is not enough force, and I'm not prosecuting.
Have there been any studies how if it's important for a woman to proceed to court for her own psychological benefit.
Interestingly enough, when I put on the rape curriculum that we've written for judges around the country, I always bring one particular expert. Her name is Dr. Veronica Reed-Ryback, and she runs the Beth Israel Hospital's Rape Crisis Center in Boston, which has done some of the major research, which, for example, showed that non-stranger rape is more psychologically damaging than stranger rape. And the judges are always very interested in this question. And she says that she has found, and I know, Linda, you agree with this, that for a significant percentage, if not the majority, of women who go through the process, even if they do not get the verdict they want, being listened to, having had the opportunity to have their day in court and speak publicly is very empowering for them.
Absolutely. Confronting the accuser, having a chance to say it, and obviously better when they triumph. I mean, that feeling of a victim saying, the catharsis of actually having the courage and strength to do that, to face your attacker, and then see that justice is done, is a remarkably helpful tool in the recovery process.
Linda, comment on the case in Seattle where a female teacher statutorily raped a young, I think it was a 13-year-old boy.
Right.
And then the judge gave it what we consider a minimum sentence of time served prior to trial. What's your comment on that?
Well, I mean, certainly the gender flip happens much more frequently. We get many cases of statutory rape where the offender is a male and the
Right.
female is underage. And
here we have a
nobody has
teacher.
any sympathy for those offenders generally, and they are sentenced. But I think, as most of the studies show, that gender differential usually results in a much harsher sentence for
Right.
the male offender.
You're a prosecutor. Tell me about it. What's your feeling on it?
I don't know what her sentence was. I mean,
Time served. I think she got off or whatever is prior to.
I don't think I would have been that lenient with her.
Yeah, I mean, because, you know, there's a double issue in this case. Not only is there an adult and a significantly older adult. I mean, a lot of the statutory rape cases you see are situations where a prosecutor feels he can't get a conviction in a forcible rape and he'll go for statutory because the guy's just over the line. But so this woman was in her 30s, a 13-year-old boy, plus this woman was in a position of trust. She was
Which
a
is the
teacher.
most
I think this
serious,
case is an abomination.
That whole issue Linda
Sends
and
out
I
the
have
wrong
frequently
signal.
discussed of this betrayal of the trust relationship, which frequently happens with teachers, with clergy, with healthcare professionals, is not covered in every aspect of the law, and it's a treacherous betrayal.
Quickly, Linda, in the moment you have left, tell me about your new novel.
Well, I'm now writing crime novels, the newer one, Likely to Die. I'm trying to do, through fiction, what Lynn and I both tried to do in real life. It's about a sex crimes prosecutor, and all of the information, all the cases in it, are based on actual cases, in this instance set in the medical community. And what I've tried to do is entertain with for people who like crime novels, but it's packed full of the same kind of information we're talking about. It's just sugar-coated.
Is there a movie in the future?
Yes, I think so.
Oh, good, good.
Want roles?
I don't know. Can we have cameos?
Absolutely.
Yes.
Linda
Okay.
Fairstein, thank you very much for appearing on Lawline.
Alan.
And Lynn Heck-Shaffrin, thank you again
Thank you,
for
Alan.
coming on Lawline. As always, this is Alan Schnorman, and thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.